Hello everyone, it's Mark and welcome back. In this video I want to talk to you about the Baker Act and whether or not I can still help you to secure your loved one's release from a facility if the facility has already filed a petition for involuntary placement. So this issue came about when a family had called me. Their daughter had been Baker Acted. She had been taken by law enforcement to a facility and the 72-hour window had closed. In other words, she'd been held for longer than 72 hours and the parents wanted their daughter back. The facility said, no, we're keeping her, and we have filed a petition with the court to keep her. And our plan is we're going to have a hearing in the next 4 or 5 days, and we're going to ask for another 2 weeks to keep her. And of course, the parents were beside themselves, and frankly, rightly so. I mean, the Baker Act, in my opinion, frankly, was borderline, meaning I'm not so sure that she even met criteria. But be that as it may, the police made that decision. That's their discretion, and they exercised it. And so the facility had then gone and filed a petition to keep her, and the family said, "Is it too late? Can you still help us?" And so, what I shared with them is what I'm sharing with you now, and what I've shared in other videos, which is the best time to try and secure your loved one's release is before the facility goes and files. Right? That's the window of opportunity to get to the courthouse first. And as I've said in other videos, the one who gets to the courthouse first usually is the winner. Not always, but most of the time. And I like to get to the courthouse first. I like to play offense. I'm not going to rely on a facility to do us the big favor of releasing your loved one when they don't even meet criteria, and their motivation is purely motivated by the fact that your loved one has health insurance, okay? Not that they want to get your loved one help. And by the way, the Baker Act statute, as I've said in other videos, is not a treatment statute. It's designed for emergency stabilization only. It's not for treatment. It's only for stabilization in emergency situations only. But be that as it may, yes, I can still help you to secure your loved one's release. First of all, I can still file my petition for habeas corpus. I don't know if the court will do anything with it because, well, the facility has gotten there first. But I can certainly still file the habeas petition. If the judge doesn't grant it, because there's a placement hearing already scheduled, the facility just may decide to capitulate. Now they know the sort of the allegations against them and the evidence that's going to come out in the hearing. I can review the petition for placement that's been filed by the facility. A lot of the time they are technically deficient, meaning they don't even meet the criteria that is required under the statute to ask a judge to move forward with a placement hearing. I can review police reports. Now in this case, the police came. Sometimes they write reports. If they do write a report, I want to review it. I want to find out if the Baker Act was even good. Okay. I can also speak to the state attorney's office and see if I can't negotiate someone's release. As I've said in other videos, these cases are treated a bit like a criminal case, except it's all done under the guise of confidentiality, meaning when there's a hearing, just like in a criminal case, there'll be a prosecutor, a judge, and a public defender, right? Just like a criminal case, except this is a Baker Act hearing. And again, your liberties is at stake. And so once that petition is filed, the state attorney's office is going to prosecute this case, just like a criminal case, on behalf of the state of Florida. Because remember, it's the state of Florida that has custody of your loved one, and now the judge is deciding should that temporary custody become more permanent in nature, anywhere from 0 to 6 months, a significant period of time stuck in a state mental health facility. And if you don't think it can happen, I'm here to tell you that it can, because I've had those phone calls from people who are in facilities, they've been ordered there for 6 months, and they want me to get them out. And frankly, at that point, it's pretty much too late. So yes, I can still help your loved one, but again, we need to move quickly, we need to review the evidence and see if we can't get your loved one out of the facility before there's a hearing. And if there is a hearing, then I'm going to go to that hearing, and I'm going to fight to get your loved one out. Now, if you don't want me to be at the hearing, you're certainly entitled, if you qualify, for the services of the public defender, or your loved one is going to get the public defender. They're all good lawyers at the public defender's office. I was prosecutor for many years, and I know many fine lawyers in the public defender's office. The problem is they're very overworked and they're very underpaid. And so the opportunity to prepare for your particular hearing is frankly diminished, right? And your loved one probably is one of 20 cases all on the same docket. And so obviously there's an advantage to preparing the case 3, 4, 5 days out from when the hearing is going to take place. And that's why I encourage you, if you can, to hire private counsel like me to help your loved one. So with that said, an interesting scenario, great question. Yes, if you hire me before the hearing, even if the placement petition has been filed, I can still help your loved one to get out. Thanks again. See you in the next video.